Because plaintiffs seek to exercise their fundamental right to marry, their claim is subject to strict scrutiny. That the majority of California voters supported Proposition 8 is irrelevant, as fundamental rights may not be submitted to a vote. They depend on the outcome of no elections. End quote. Under strict scrutiny, the state bears the burden of producing evidence to show that Proposition 8 is narrowly tailored to a compelling government interest. Because the government defendants decline to advance such arguments, the proponents seize the role of asserting the existence of a compelling California interest in Proposition 8. As explained in detail in the Equal Protection Analysis, Proposition 8 cannot withstand rational basis review. Still less can Proposition 8 survive the strict scrutiny required by plaintiffs' due process claim. The minimal evidentiary presentation made by proponents does not meet the heavy burden of production necessary to show that Proposition 8 is narrowly tailored to a compelling government interest. Proposition 8 cannot, therefore, withstand strict scrutiny. Moreover, proponents do not assert that the availability of domestic partnership satisfies plaintiffs' fundamental right to marry. Proponents stipulated that there is a significant symbolic disparity between domestic partnership and marriage. Accordingly, Proposition 8 violates the Due Process Clause of the 14th Amendment. The Equal Protection Clause of the 14th Amendment provides that no state shall deny any person within its jurisdiction the equal protection of the laws. End quote. Equal protection is, quote, a pledge of the protection of equal laws. End quote. The guarantee of equal protection coexists, of course, with the reality that most legislation must classify for some purpose or another. When a law creates a classification but neither targets a suspect class nor burdens a fundamental right, the court presumes the law is valid and will uphold it as long as it is rationally related to some legitimate government interest. The court defers to legislative, or in this case popular judgment, if there is at least a debatable question whether the underlying basis for the classification is rational. Even under the most deferential standard of review, however, the court must insist on knowing the relation between the classification adopted and the object to be attained. End quote. Basis for the classification must find some footing in the realities of the subject addressed by the legislation. The court may look to evidence to determine whether the basis for underlying debate is rational. Finding an asserted interest in preserving the state resources by prohibiting undocumented children from attending public school to be irrational because the available evidence suggests that illegal aliens underutilize public services while contributing their labor to the local economy and tax money to the state FIC. End quote. So that's all about, a different case. It's a bit confusing there. Just kind of led right into that. Sorry. Continuing. The search for rational relationship, while quite deferential, ensures the classifications are not drawn for the purpose of disadvantaging the group burdened by the law. The classification itself must be related to the purported interest. It is difficult to conceive of a rational basis for penalizing undocumented children for their presence within the United States, despite the state's interest in preserving the state's resources. Most laws subject to rational basis easily survive equal protection review because a legitimate reason can nearly always be found for treating different groups in an unequal manner. Yet to survive rational basis review, a law must do more than disadvantage or otherwise harm a particular group. Plaintiffs challenge Proposition 8 as violating the Equal Protection Clause because Proposition 8 discriminates both on the basis of sex and on the basis of sexual orientation. Sexual orientation discrimination can take the form of sex discrimination. Here, for example, Perry is prohibited from marrying Steyer, a woman, because Perry is a woman. If Perry were a man, Proposition 8 would not prohibit the marriage. Thus, Proposition 8 operates to restrict Perry's choice of marital partner because of her sex. But Proposition 8 also operates to restrict Perry's choice of marital partner because of her sexual orientation. Her desire to marry another woman arises only because she is a lesbian. The evidence at trial shows that gays and lesbians experience discrimination based on unfounded stereotypes and prejudices specific to sexual orientation. Gays and lesbians have historically been targeted for discrimination because of their sexual orientation. that discrimination continues to the present. As the case of Perry and other plaintiffs illustrates, sex and sexual orientation are necessarily interrelated, as an individual's choice of romantic or intimate partner based on sex is a large part of what defines an individual's sexual orientation. Sexual orientation discrimination is thus a phenomenon distinct from but related to sex discrimination. Proponents argue that Proposition 8 does not target gays and lesbians because its language does not refer to them. In so arguing, proponents seek to mask their own initiative. Those who choose to marry someone of the opposite sex, heterosexuals, do not have their choice of marital partner restricted by Proposition 8. Those who would choose to marry someone of the same sex, homosexuals, had their right to marry eliminated by an amendment to the state constitution. Homosexual conduct and identity together define what it means to be gay or lesbian. Indeed, homosexual conduct and attraction are constitutionally protected and integral parts of what makes someone gay or lesbian. Our decisions have declined to distinguish between status and conduct in the context of sexual orientation. Proposition 8 targets gays and lesbians in a manner specific to their sexual orientation, and because of their relationship to one another, Proposition 8 targets them specifically due to sex. Having considered the evidence, the relationship between sex and sexual orientation, and the fact that Proposition 8 eliminates a right only a gay man or a lesbian would exercise, the court determines that plaintiff's equal protection claim is based on sexual orientation, but this claim is equivalent to a claim of discrimination based on sex. As presently explained in detail, the Equal Protection Clause renders Proposition 8 unconstitutional under any standard of review. Accordingly, the court need not address the question whether laws classifying on the basis of sexual orientation should be subject to a heightened standard of review. Although Proposition 8 fails to possess even a rational basis, the evidence presented at trial shows that gays and lesbians are the type of minority strict scrutiny was designed to protect. Noting that strict scrutiny may be appropriate where a group has experienced a history of purposeful unequal treatment or been subjected to unique disabilities on the basis of stereotyped characteristics and not truly indicative of their abilities. Proponents admit that same-sex sexual orientation does not result in any impairment in judgment or general social and vocational capabilities. The court asked the parties to identify a difference between heterosexuals and homosexuals that the government might fairly need to take into account when crafting legislation. Proponents pointed only to a difference between same-sex couples who are incapable through sexual intercourse of producing offspring biologically related to both parties, and opposite-sex couples, some of whom are capable through sexual intercourse of producing such offspring. Proponents did not, however, advance any reason why the government may use sexual orientation as a proxy for fertility, or why the government may need to take into account fertility when legislating. Consider, by contrast, City of Claiborne versus Claiborne. I thought I edited that bit out. Sorry about that. Legislation signaling out a class for differential treatment hinges upon demonstration of real and undeniable differences between the class and others. Physical differences between men and women are enduring. End quote. No evidence at trial illuminated distinctions among lesbians, gay men, and heterosexuals amounting to real and undeniable differences, end quote, that the government might need to take into account when legislating. The trial record shows that strict scrutiny is the appropriate standard of review to apply to legislative classifications based on sexual orientation. All classifications based on sexual orientation appear suspect, as the evidence shows that California would rarely, if ever, have reason to categorize individuals based on their sexual orientation. Here, however, strict scrutiny is unnecessary. Proposition 8 fails to survive even rational basis for review. Proposition 8 cannot withstand any level of scrutiny under the Equal Protection Clause, as excluding same-sex couples from marriage is simply not rationally related to a legitimate state interest. One example of a legitimate state interest in not issuing marriage licenses to a particular group might be a scarcity of marriage licenses or county officials to issue them. But marriage licenses in California are not limited in commodity, and the existence of 18,000 same-sex married couples in California shows that the state has the resources to allow both same-sex and opposite-sex couples to wed. See background to Proposition 8 above. Proponents put forth several rationales for Proposition 8, which the court now examines in turn. 1. Reserving marriage as a union between a man and a woman and excluding any other relationship from marriage. 2. Proceeding with caution when implementing social changes. 3. Promoting opposite-sex parenting over same-sex parenting. 4. Protecting the freedom of those who oppose marriage for same-sex couples. 5. Treating same-sex couples differently from opposite-sex couples. And 6. Any other conceivable interest.